Hi, I'm Ben Vojtik, and I'm here to talk to you about jurisdiction in family law cases. Now, jurisdiction becomes a question in family law cases when you live in one state and are served with family law papers from another state, whether it's divorce, custody, or support. If you live in one county and are served with papers from another county, that isn't a jurisdiction question, that's a venue question. Now, there are two different types of jurisdiction questions in family law cases. There's subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction concerns whether the court has authority to make child custody orders. See, most states have passed what is called the Uniform Child Custody Jurisdiction and Enforcement Act, or UCCJA. And this primarily gives the court with home state jurisdiction over the minor child authority to make custody orders. Now, that's if a minor child has resided in a state for 6 months or more, and that being the last state in which the child has resided 6 months or more. There are certain exceptions to this, especially if you're in a military family. If you were stationed somewhere, that doesn't necessarily make that location the minor child's home state. For example, if you're stationed in Guantanamo, no court in Guantanamo is going to be making child custody orders. And then there's personal jurisdiction. Personal jurisdiction concerns whether the court has jurisdiction to make orders over your person. And there are three different ways of establishing personal jurisdiction. There is domicile or residence. Do you reside in the state? If you do reside in the state, then that state has jurisdiction over you. And then there's service in the state. If you are served in the state in which you are being sued for divorce or custody or support, then that state does have jurisdiction over you. You can still contest that jurisdiction maybe on grounds of inconvenient forum, but that is another issue that would greatly complicate this video. And then there is minimum contacts. Do you have sufficient contacts with the forum state, sufficient for them to exercise jurisdiction over your person? Do you regularly travel to the forum state? Do you work in that state? Did you get married in that state? Did you have sex resulting in a minor child in that state? All of these things are concerns as to whether that state would have jurisdiction over you. And their case law has set forth a number of different considerations that I don't have time to discuss in this video. Now, the way these two interact with each other is a little bit different. It's very possible that a state have subject matter jurisdiction over the minor child, but not have personal jurisdiction over you. So in this situation, the court could make custody and visitation orders, but not be able to make support orders. Now, personal jurisdiction is very easily waived, whereas subject matter jurisdiction is never waived. Personal jurisdiction can be waived if you file a response to their petition and don't raise the personal jurisdiction objection. It would be waived if you waited too long and missed your opportunity to file a response, or waited past the time for you to file a response and didn't raise the personal jurisdiction objection. Personal jurisdiction can also be waived if you oppose a motion without raising the personal jurisdiction objection. Now, there are a couple exceptions to this waiver, but for the most part, if you do anything, you can waive this personal jurisdiction objection, which is why if you live in one state and are served with papers in another, it is important for you to contact an attorney as soon as possible. This is a complicated issue. There's a lot of things to consider, and it is extremely easy to waive those objections. So I hope I've been helpful. My name is Ben Vojtik. Thank you and have a good day.